There's some major news right now about the push to eliminate the last remaining restrictions on suppressors under the NFA. Over the past few weeks, we've seen serious movements, legislative, legal, and cultural, all converging at the same moment. By the time this video goes live, we're just days out from a key milestone that's reshaping how these regulations are interpreted and enforced. Congress recently passed a sweeping piece of legislation that fundamentally changes the NFA's application to suppressors and similar items. It wasn't front-page news in the mainstream outlets, but if you care about your rights, especially those guaranteed under the Second Amendment, this matters. The bill, which has quickly picked up the nickname the Big Beautiful Bill, included something we've been hoping to see for years: the elimination of the NFA's $200 tax for suppressors. That tax has been a fixture since the 1930s, originally designed to deter ownership, not to raise revenue. And now, after decades, it's gone, reduced to zero. That's not just a change in numbers. That's a signal. It means something bigger is happening, and the legal world has taken notice. Of course, the law didn't go as far as many were hoping. It didn't remove suppressors or short-barreled rifles and shotguns from the NFA entirely. The registry still exists, and many of the same bureaucratic hurdles are still in place. But the tax change has opened a crack in the door, and that crack is wide enough for a legal challenge to slip through. And that's exactly what's happening. The conversation is no longer just about reform. It's about dismantling outdated barriers completely. One of the biggest problems gun owners have faced for years is legal ambiguity. Even well-meaning, law-abiding people have found themselves in serious legal trouble for violating rules they didn't even know existed. The structure of these regulations, federal on one side, state on the other, often in conflict, creates traps. You think you're fine, then you're not. You think you're compliant, then suddenly you're looking at felony charges. That uncertainty is what this new wave of lawsuits is aiming to destroy. In the days following the tax reduction being signed into law, a wave of litigation began. One of the earliest lawsuits was filed in the Northern District of Texas. It came from a coalition of advocacy organizations, manufacturers, and retailers, and it targets what's left of the federal NFA registry. Their argument is direct and difficult to ignore. If the tax is now zero, then the registry no longer serves its original purpose. It's not regulating commerce. It's not producing revenue. It's just creating a barrier to exercising a constitutional right. And under current legal standards, that's not enough. But the fight isn't stopping at the federal level. Around the same time, a second lawsuit was filed, this time in New Jersey. Unlike the federal system, New Jersey still bans suppressors outright. No registration, no exceptions. A total prohibition. The plaintiffs in this case are using the same turning point, the elimination of the tax, to challenge the state's authority to maintain a ban that's increasingly out of step with both federal law and constitutional precedent. The timing of both lawsuits is no coincidence. Legal experts have been waiting for a change like this to create momentum. That $0 tax isn't just a number, it's a foundation for argument. It forces the courts to reevaluate the necessity and legitimacy of laws that are no longer serving their stated purpose. That's why this moment matters. It's not just a step forward, it's a shift in the legal terrain. We're seeing energy, coordination, and strategy that feel very different from past efforts. These are not symbolic gestures. These are targeted legal attacks designed to chip away at the core of outdated restrictions. And what's most important is that they're rooted in the Constitution itself, not in ideology, not in trends, but in the plain text of the Second Amendment. The New Jersey case, officially titled Padua vs. Platkin, is not just another line in a long list of Second Amendment lawsuits. It represents a direct confrontation between state-level prohibition and federal recognition of constitutional protection. The plaintiffs in this case include some of the most prominent gun rights organizations in the country. They've come together to challenge New Jersey's complete ban on the possession and use of suppressors, and they're building their case on solid constitutional ground. At the center of the argument is a simple idea. Suppressors are arms. Under the plain text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed. And if suppressors are classified as arms, and the federal government has already admitted they are, then outright bans like the one in New Jersey cannot stand. The case points directly to the Fifth Circuit's decision in the Peterson Challenge, where the Department of Justice under the previous administration acknowledged that suppressors are indeed protected arms under the Second Amendment. That acknowledgement matters. It wasn't some offhand comment. It was a formal recognition by the federal government that suppressors fall under the category of constitutionally protected tools of self-defense. And when the DOJ says that states cannot outright ban them, it becomes very difficult for any state government to justify a total prohibition without running headfirst into a constitutional wall. In their legal brief, the plaintiffs argue that New Jersey's ban violates the Second Amendment because it prevents peaceable citizens from possessing and carrying a common arm that is widely permitted across the United States. They go further by pointing out that suppressors serve legitimate, lawful purposes. They reduce the risk of hearing damage, they make home defense more viable in close quarters, and they enhance the effectiveness of firearms for exactly the kinds of lawful uses protected under the Constitution: defense of self, family, and property. But it doesn't stop there. The lawsuit also emphasizes how common suppressors have become. 42 states currently allow private ownership and use of suppressors. That's not a fringe movement. That's the overwhelming majority of the country. Suppressors aren't exotic or experimental. They've been in use for over a century. They are regulated, registered, and until recently, taxed, but they're widely accepted. And that commonality makes New Jersey's complete ban look even more extreme and unjustified. The brief also draws attention to international standards. In many countries around the world, suppressors are not only legal, but encouraged for public safety reasons. In places like Finland and New Zealand, suppressors are considered polite, a courtesy to others. The U.S. stands out in its regulatory hostility toward them, especially in states like New Jersey. That contrast helps illustrate just how disconnected some local laws are from global and national norms. What the plaintiffs are asking for is straightforward. First, they want the court to declare that New Jersey's ban on suppressors is unconstitutional. Second, they're asking the court to prevent state officials, law enforcement, and regulatory agencies from enforcing the ban. In other words, not only do they want the law overturned, they want to block any attempt to revive or enforce it in any form. This case has the potential to be a major turning point. If the court rules in favor of the plaintiffs, it would strike down one of the most restrictive suppressor laws in the country. But more importantly, it could create a legal precedent that can be cited in other states with similar bans. The ripple effect could extend far beyond New Jersey. Meanwhile, in Texas, the challenge to the federal registry continues. That lawsuit is equally significant because it questions the entire premise of requiring registration for items that are no longer taxed. If these two cases progress successfully, if they hold up under appeal and reach higher courts, we could be looking at the beginning of a complete dismantling of the most burdensome parts of the NFA. We've seen organizations like the GOA and SAF lead these charges before, but the coordination happening now feels sharper, more deliberate. There's a clarity of purpose that hasn't always been present. These aren't isolated legal stabs in the dark. They are linked strategies, forming a two-front assault, one against federal overreach, the other against unconstitutional state law. What makes this moment even more interesting is how the federal government might respond. In the past, it was not uncommon for federal agencies to stay silent or even oppose these kinds of challenges. But that trend has started to shift. In recent years, we've seen the Department of Justice take a more nuanced position, especially under administrations that recognize the fundamental rights guaranteed by the Second Amendment. In some recent firearm-related lawsuits, the DOJ has even filed amicus briefs arguing that state-level bans, whether on rifles, magazines, or other common arms, cannot survive constitutional scrutiny. There is reason to believe we'll see something similar here. The recognition of suppressors as protected arms was already put on the record. That acknowledgement didn't come from a fringe group or a minor agency. It came from the DOJ itself. If that stance holds, and if the current administration doesn't reverse course, there's a real chance the federal government could support, or at least not oppose, these lawsuits moving forward. The ripple effect of that would be huge. If one or both of these cases succeed, it won't just mean freedom for gun owners in Texas or New Jersey. It will be a signal to other states, courts, and lawmakers that the era of overregulation is coming to an end. It would also give advocacy organizations a powerful new tool. A favorable ruling would serve as a precedent, giving them a legal roadmap for similar challenges in places like California, Massachusetts, or Illinois, anywhere suppressors or other NFA items are still unfairly restricted. And it's not just about suppressors. If the legal theory behind these cases proves successful, it could apply equally to other NFA-regulated items like short-barreled rifles and shotguns. Those items remain heavily restricted in many states. But the same arguments apply. They are in common use. They serve legitimate self-defense purposes, and bans on them do not align with the historical tradition of firearms regulation. We could also see this spark a deeper review of the NFA itself. The National Firearms Act was passed nearly a century ago. It was created in a time of organized crime, Prohibition-era violence, and deeply flawed assumptions about firearm ownership. Many of its provisions have gone unchallenged for decades, not because they're constitutionally sound, but because the system made them difficult to contest. That's changing. The tax reduction opened a legal doorway. Now these lawsuits are stepping through it, and once the courts engage with these questions directly, there's no telling how far the impact will reach. This is the kind of moment that will be remembered later as a turning point, not a dramatic one-day shift, not a headline-grabbing event, but a slow, strategic rebalancing of the law, one based on constitutional principle, historical context, and common sense, one that began with a single change to the tax code and might end with a reshaped landscape of firearm rights across the country. If you've made it this far, you already understand how important these developments are. Whether you're in a state with heavy restrictions or one that's already more permissive, the legal landscape is moving, and it's moving fast. These cases, these arguments, and these shifts in legal doctrine are not distant courtroom battles. They affect real people. They shape what's possible. They define what's allowed. Stay aware of what's happening. Pay attention to the outcomes of these cases. Support the organizations pushing for constitutional clarity. And more than anything, stay informed, because the more people understand the reality of these issues, the harder it becomes for fear, confusion, or misinformation to win.